Hi, everyone. I'm Greg Lambert from the Geek and Review, and I've got Stephanie Wilkins from Legal Technology Hub with us today, and we're going to talk about the head-to-head analysis.
Yes. Hi, Greg. Thanks for having me. One of the types of content that you'll find in our LTH premium subscription is what we call a head-to-head analysis, and we're in the process of working on a few more of these now coming up soon. So what they essentially are their market reports on a very niche area of legal tech, where there's a relatively small subset of tools that address a very specific use case or problem. So in that head-to-head article, we'll explore the problem first. Then we set out why it's a pain point for lawyers or why it's manual or time consuming. And then we compare in detail the different providers in the area. So we're usually talking about a space where you have, say, 4 products in the area, and we'll provide a grid with details about each of those 4 products in terms of the company itself, when and where it was founded, who the founders are, etc. And then the product, where we'll list all the major features a user would expect for a product in that niche category. And then we identify which of the products have those features or how those features are deployed within each of the products. Or if a product doesn't handle one, for example, that gives you a chance to do that head-to-head comparison. We also touch on security, data privacy, and data hosting information for each of the products, so buyers can see the grid and assess relatively quickly which of the products is more likely to suit their individual needs. Um, Additionally, we of course also on the on our database, on our directory itself, we offer a compare feature that always allows you to compare any product against any 4 other products, 4 or fewer, in a graded format. But our head-to-head goes far deeper into the product features than that compare feature does. So we're providing a more granular comparison on a very specific problem area. In the past, for example, we've done head-to-heads on tools that automatically create discovery responses, structure diagramming tools, and deal intelligence solutions. And we have quite a few more of these lined up for release in the coming weeks and months. I know I have a couple ideas myself on discovery and litigation areas where there's a small number of tools handling very discrete but important problems. But if you keep an eye out on legaltechnologyhub.com and make sure you sign up for our free newsletters, you'll get notified when the next time the next head-to-head is released.
Sounds great. Thanks, Stephanie.
Thanks.
Welcome to the Geek and Review, the podcast focused on innovative and creative ideas in the legal industry. I'm Marlene Gaybauer.
And I'm Greg Lambert. And this week we're speaking with the founder of what's being called the first AI-powered law firm approved for practice in the UK. Philip Young is the co-founder and CEO of Garfield AI. And just a little backstory here. In April of 2025, so just a month ago, Garfield became the first Solicitors Regulation Authority, or SRA, regulated law firm in the UK that uses AI at the heart of its service delivery. The platform helps small businesses recover debts up to £10,000. For us in the US, it's about $12,500 or so. And it uses the small claims process in England and Wales quickly, affordably, and with very little human interaction. So, big introduction. Philip, thank you very much for taking time to talk to us on the Geek and Review.
Thank you for the introduction. Very nice to meet you both.
Yeah, thank you. Thank you for joining us. So,
yeah. But so before we jumped in, I was reading a story this week where a court allowed here in the U.S., and I don't have all the details here, but a court allowed the family of a victim of I believe it was a DUI accident who had died.
And it was
a
road rage accident.
Oh, road rage. That's right. It was road rage. To basically recreate this person using AI to present to the court this person's own life story. So, Marlene, I know you read a little bit about it as well.
I saw that David Hobby posted it, and I was just like, oh my gosh, this is kind of amazing. But yeah, it was. I mean, it's a sad story, but also, from a technology point, just a real fascinating story. And what they did is they created an avatar of him, and they used his likeness and his voice, to just basically talk about himself. And essentially, he was saying, I'm sorry, we met the day, the day we did, because, otherwise, we might have been able to be friends. And from what I understand, like everybody was in tears, and it's an example of the real impact that, avatars and real voices, can make on people.
Yeah, yeah. So, and Philip, I don't know in the UK if you have road rage like we have here, like here in Houston, uh, but it's a real thing here.
It's a real problem.
We do have this in England as well. I'm not sure we've got quite to the point where we have AI avatars of people that were actually a victim of the incident appearing in court. That's very much the future. I was saying to people about 2 years ago when ChatGPT 3.5 was released and then ChatGPT 4 was released, that I felt a bit like a 19th century canal owner who's standing by the side of his canal enjoying his business, and then he sees George Stephenson's rocket go past on rails and thinks, that is the future. And that very much, with this sort of story and other sort of things, I think it's very much sort of been my mindset for the last 2 years.
Yeah, yeah. Well, in this sort of dovetails in I don't know if you saw this story earlier from a couple of weeks ago, where someone I believe it was in New York, was doing an appeal, and in front of us, I think it was a 7-panel judge panel, and was giving a video, and it turned out the video was an AI avatar that and immediate. I mean, it was shut down immediately. The judge figured it out.
Oh, hell no.
She was not having it. But I have to say, I felt kind of sorry for the guy, because I think he was honestly trying to do something with the technology to help himself that wasn't, I don't think it was really that harmful. It was no worse than reading a script to the court. But he was saying, look, I get extremely nervous when I talk, and especially, in these situations. So I thought this would be a better way for me to present
tell my story,
the story to the court. In that case, the judge wasn't having it, but I think it might be something we see more and more of.
There's also a risk here as well. So I saw a video only about a month or so back of somebody who was on a Zoom call, and they had put side by side what they were actually doing on the Zoom call, which was walking around the room and standing up, versus what the people who were watching the Zoom call could see, which was them sitting down, staring at the camera, being very professional. And I was a litigator for 25 years in practice in London, and I sort of broke out in a cold sweat when I saw that, because I thought, goodness me, so many hearings now in the English court system are operated with some evidence remotely. And if you can't trust what you can see, then you have to then think about what safeguards and guardrails you build in to protect the authenticity of the evidence that's given. And obviously there's going to have to be more thought applied to that, because judges have got to know who's in their court, who's in attendance, and got to be able to see the witness and what they're actually doing. I mean, in a fraud case, it could go from trying to detect something from the witness's demeanor, and you can't do that because they look perfect. They look very credible, and they're not sort of sweating under the pressure suddenly. So, and I imagine, sorry, Marlene, you were going to say something.
I was just saying, as the whole deep fake issue, this is something that you really have to think about in terms of admitting evidence. And Philip, what you were saying as a litigator, like if everybody looks perfect, like you can't read, like you can't figure out what their tells are, and be able to take advantage of that as a litigator. So totally understand that.
No, you're right. I mean, it does apply as well to things like settlement negotiations, because if you're in a room with the other side, you want to be able to say, as you say, what their tells are. So there's quite a lot of thought that's going to have to be applied to this to work out how to protect from mischief occurring.
Mm-hmm. Yeah, we have one specific litigator at our firm who's like 6'8", and when COVID hit and he was having to do all of his work remotely, he says it really took away his advantage of being an imposing character there in the courtroom. So.
You can't sort of loom over people anymore, is what you're saying.
Yeah. We're all the same height on Zoom, I guess.
That's right. All right. So Pod Dog may or may not come in to join us, and so I'm gonna just soldier on here and hope for the best.
Good luck.
So, like Philip, if we were interviewing you this time last year, we'd be talking about you being a pretty formidable litigator at Cook, Young and Keaton, a firm that you co-founded and were named partner. But today, people, of course, know you from your work at Garfield, and this marks a really different chapter. So what led you to create an AI-powered litigation tool, and how did your personal or professional experiences influence the path?
So yeah, so the road to Garfield is a slightly uneven one. So the necessary backstory for me is that I'm not just a lawyer, I'm also a very big nerd. And like a lot of my generation, when the 1980s happened and we were young, we had the big explosion of 8-bit computers. And in this country, we had I don't think there were computers that particularly made their way into America, but we had the ZX Spectrums that had the little wobbly keys, and then we had the BBC Micros that were everywhere because every school had them. They were promulgated by the BBC. The government was very keen on them, and they really made an entire generation computer literate. So I learned to program then, and I've always enjoyed mucking about with computers. Fast forward a bit, and I was in practice for 25 years. I was originally in practice at Baker and McKenzie, which is a firm you guys will have heard of course, because you don't get more global than Baker and McKenzie, and of course founded in Chicago too, and then in practice for 13 years at one of the firm I co-founded, CYK, which is an excellent London litigation arbitration boutique, and I then decided post-COVID that I'd spent rather too much time staring at people over a screen. Lovely though it is, it's not as engaging as seeing people in real life. And if you're a litigator, you tend to be quite gregarious and all of those sort of characteristics. So I thought I deserve a break. So I retired, and I retired in the sense of English partnership law, not in the sense of age, because I'm not quite old enough for retirement yet, although I'm heading that direction. And then I went across America for 3 months on a road trip from Boston to Seattle. And we went the northern route, so we went up into New England and then across below the lakes, Cleveland, Chicago, across the Great Plains and Wyoming and Colorado. And by the way, I know I'm mostly talking to an American audience, but America is a fantastic country, just amazing people, amazing scenery. It's just a shame that I couldn't spend more than 3 months in America. But while I was there, ChatGPT 3.5 was released, and I obviously had time on my hands, and I was a big nerd, so I had a bit of a play. And the more I played with it, the more I thought, gosh, this thing is going to really change the way that legal services are provided. And then I stopped because I was having far too much fun in your country. And then a few months later, in sort of April, May time, 2023, ChatGPT 4 was released. And that was a big jump in capability. And then I thought, well, I'm not in practice. I've got time on my hands. I could do something that would engage me because it's nerdy as well as legal. What do I do? And then what I thought about was my brother-in-law, a lovely guy called Andy, who lives near Sheffield, a city in England. Sheffield may not be at the top of the cities that Americans think of when they think of England, but if you think of people like Sean Bean and the musician Joe Cocker, they all come from Sheffield. Very much a northern city, very much an industrial city, lovely place. So Andy's a plumber, and Andy's problem from time to time is a problem all small business people have, which is that sometimes people just won't pay him, which is a problem for him because if it's insolvency, well, that's just a risk of doing business. If there's a problem with the service, well, that's something he needs to fix. But often it's just people that know that small business people do not have the time to spend chasing unpaid debts, and certainly don't want to be filling in court forms because that sort of thing is daunting. And so I would, as a brother-in-law, I would help him. A little bit of a change from city practice, but I would help him get that sort of money. Because for somebody like Andy, a sum of £2,000 to £3,000 is a summer holiday, is really, really important. And while I was doing that, I always thought the small claims process in England and Wales, although it is designed to be simplified, efficient and quick, inevitably it's not really any of those things. And I always thought there's too much friction here and we need to have a better solution. And so I started to think about Andy when I saw ChatGPT 4, and I thought, why not try and build something that helps the Andys of this world? And so that's where Garfield comes from, is really an attempt to make my brother-in-law's life a little bit easier, and all the people like my brother-in-law's life a little bit easier. And if you want, I can talk a bit about how we started to build the team, or you've probably got another question.
Yeah, no. Let's dig in there a little bit more. Talk to us about how you worked on the development of it. Any kind of iterations, what it looked like initially versus what it looked like when you finally were ready to present it. So if I were new to Garfield, how would you explain it to me?
So Garfield is essentially an attempt to replicate what a good law firm would do in helping somebody go through the small claims court system in England with a debt claim. So a sum up to £10,000, as you mentioned earlier, Greg. And so the way it works is very much, it follows our procedural rules. So when someone comes into Garfield and they've onboarded and they've passed all the AML and KYC requirements that every law firm in the world now has, they will drop an invoice or many invoices into Garfield. And if they've got a contract, written contract, they can drop that in as well. Garfield reads those documents, it pulls out the relevant information, it checks whether or not the claim is a valid claim. So if, for example, it's over the £10,000 threshold, or there are issues that would mean it's not a small claim in reality, or there's a problem of limitation, or say there's an arbitration clause in the contract, all sorts of invalidating features, then Garfield can't help you. But if you are genuinely a small debt claim, then Garfield can help you, and then we'll tell you what it's understood, and then we'll recommend the next step, which in England is a pre-action letter that sets out the demand for payment of the debt. And we have a protocol in England that says what the letter has to say. And if you read it, you'd be like, that's all common sense. It's all, how much is the debt? What's it being incurred for? When's it due? What the interest rate is? And then Garfield takes you through all the steps of the process. So if you don't get payment in response to the letter, Garfield will draft the claim form and the particulars of claim, which are the originating documents that the court here needs to start court process. And Garfield will then, once you've approved those, send those to court. The court issues and serves them. And then Garfield takes you through whichever way your case goes. So if the debtor pays you, which we hope, of course, that they do, then Garfield is finished. Garfield has done its job. If the debtor says, I will pay you, but I need time and indulgence, Garfield will handle that. If the debtor ignores the case entirely, Garfield will help you apply for a default judgment and send those documents to court. And finally, in the relatively small percentage of cases every year that get defended, and statistically it's about 2 to 5%, Garfield will help you go through the steps of dealing with the defense, doing document production, which is a very limited thing in the English small claims court, and then take you to the very doorstep of the 1-hour small claims court trial. And for the trial stage, Garfield generates a little PDF court bundle of documents, a little skeleton argument, which you guys would call a brief. I always wonder why they're called briefs, because whenever I've seen a brief or a skeleton, they're not skeletal or brief. And a little note of advice, because you may never have been to court before. So things like put on a suit, turn up at court on time, address this judge by this particular form of words, and that's the basic idea behind Garfield. It's supposed to sort of hold your hand going all the way through the court process. The other thing that's really relevant is that I haven't, with Dan and our team, who are completely awesome, and I will just talk a bit about them in a moment if you'd like, I haven't just built this for non-law firms. We've also very much built it for English law firms to use as well, as a sort of white label product, because I'm really keen to create a platform that gives people choice. Because lots of people, when presented with an AI product, they might say, I'll give it a go. But lots of people also say, I want to use a human overseen solution. So we built it for both. And we're very interested to see, actually, so far, the take-up has been from both sort of wings of the both types of businesses.
Yeah, and I've seen where all of this, depending on, I guess, the level of service needed, can be as little as £2 or about $2.50 here in the U.S. At what point in this is there any kind of human interaction to kind of verify what's going on behind the scenes, or if someone has a question? Is there some is there some way for a human to kind of verify or to talk to them? So
one thing about being a lawyer, particularly a lawyer for a long time, is it makes you cautious, I think. Very rare to meet an uncautious lawyer, and I'm no exception. And I think with AI and any sort of new product, you've got to be both responsible and accountable. Those are sort of the two key themes, I think. And so as part of the process of becoming regulated, I was very keen to agree with the SRA that we would roll out in a measured fashion. We wouldn't just open the doors and let the floodgates roll in. And also that I would, at the beginning stages, sort of oversee all of the cases going through the system. Now, in the longer term, of course, that's not realistic. And the plan is to move, as the regulators also said, to move eventually to a sort of sampling process, because a lot of documents in small claims are either template driven or the possible range of the possible universe of types of documents is at least confined. It's not infinite. And that means that you can eventually, with a large enough data set, apply analytics and mathematically examine the accuracy of your document against what you've received. And so over time, I will move very much to we have this mantra in England in all of our regulators where we talk about risk-based approach to things. And so I will move very much to a risk-based form of supervision, where I will focus my attention primarily on the parts of the case that are the most risky. In other words, a defended case, where you actually have a defendant who is fighting. And so that's a longer term plan. But for the time being, at least, I'm checking everything. Obviously, I have been building this product for 2 years, so there's been an awful lot of testing along the way as well. I wouldn't have launched it unless I felt that it was of an acceptable level of quality at this point in time.
All right, so now you have given me like three questions just from what you said. So the first one is, you mentioned that you're getting interest from both like pro se people and also from law firms. So how is the marketing different for each of those? How do you? I mean, I probably have a pretty good idea about the firms, but how do you sort of get in front of sort of the regular folks that would be using this?
Well, we weren't actually expecting to be in the public domain at this stage. We weren't actually expecting the FT, the Financial Times in London, to pick up on this and to publish about us last Monday. And since they did, as I have mentioned online, my phone has melted with the sheer number of messages and emails. And I've been trying to sort of manage my way through the last week and a half whilst also continue to do my day job, so to speak. So marketing hasn't really been at the forefront of my mind. And
don't need it.
I haven't needed
the Financial Times did it for you.
I haven't had much time to do that. At some point, I imagine we will do some proper marketing, but I think it's sort of early days still. What's been amazing is the reaction actually of the profession in England and Wales, and also more globally, that people have been incredibly positive about this sort of development for legal practice. And I think if I had any concerns before about the fact that we lawyers, we're not renowned, are we, as a profession for being incredibly modern and forward thinking. And I can think of examples in my career when I was in front of High Court judges up to 20 years ago, and they would try and analogize a computer with a quill because they'd never used a computer and had no idea how it worked. And now we're moving into a world where even judges can use things like Excel and can manipulate PDFs. And I think it's quite fortunate actually that it means that the profession is a lot more sort of forward thinking and willing to embrace things.
Okay. Now my next question is, so Garfield AI, how far does it take the claimant into the process? Is it just sort of getting to court? Or does, like, after judgment occurs, does it also give advice?
So at the moment, it goes up to the doorstep of the 1 hour small claims trial. Interestingly, a lot of people will be talking about the fact that with the current rate of technological development, it may be possible for AI to do advocacy. I can see why that may become possible. I have to say, personally, philosophically, I'm not enthusiastic about AI doing advocacy in anything other than tiny claims, because I think people should be represented by people in court, because it's more than just a process. It's also a very human experience. Sometimes just because you need a lawyer there, because sometimes clients need a shoulder to cry on, frankly. And that's why we're all amateur psychologists in a way, aren't we? That's as far as it's got at the moment. I think we will build a judgment enforcement module.
That's
as it happens in England,
thinking.
we've got a process underway at the moment to try and modernize the enforcement of money judgments. So it will sort of slot nicely into that, I think, because there's a desire to digitize that a lot more.
Mm-hmm. All right, and then the final question that I had from your what you were saying before is, you were talking about analytics, and So you're looking at it in terms of risk and sort of where there's argument, and I think that would be very valuable. Are you also looking at it to share with the courts in terms of, types of claims that are coming through, what the resolutions are, things like that?
I would like to be able to do that. Yes. So I think one of the things I've been very conscious of, particularly in the last week and a half, is that because we are the first, we owe a sort of good citizen obligation to the powers that be, so the judiciary, the political establishment, those sorts of people, to try and help. And so as Garfield develops and as we end up with data, then subject to my professional rules around client confidentiality, if I can help them with data to help them deal with bottlenecks and things in the system, then I would be delighted to do that. The Ministry of Justice in our country does have reasonably advanced computer systems, not as advanced as they would like. And there's a lot of work being done to try and make them a little bit more 21st century capable, but they therefore do collect quite a lot of data already and publish it. But I don't think they collect as much data as they would like to do. And products like Garfield will help.
Good. Yeah, it's always good to make data-driven decisions.
Exactly.
Yeah, exactly.
Exactly.
Yes. Rather than emotional-driven decisions.
But let's talk about the SRA, because maybe some of our listeners don't really know much about the SRA. I mean, I know for sure that I do not. So, but I know that getting SRA approval is no small feat, especially when you're the first to ask them to approve an AI-based law firm. So tell us about the process. What were the guardrails? What were the controls that you needed to put into place to meet the regulatory standards?
So, yeah, let me just give you a bit of context first. So, as many of you guys will know, England has a split legal profession. So we have barristers who are specialist advocates, and they are regulated by the Bar Standards Board. And they have all these delightful ancient traditions that Americans in particular tend to like. So, for example, to become a barrister, you have to eat a set number of meals in the Inns of Court in London. So you've got to demonstrate the ability to eat, which is obviously a helpful ability if you want to keep living. And other things as well. There also has to be some legal ability. Whereas my side of the profession, we're known as solicitors, and we have a different regulator, the Solicitors Regulation Authority. If you go back in time, we were once known as attorneys as well, but the title was changed. And I was told years ago it was because the title of attorney in England had fallen into disrepute, and we were basically rebranded. Now, I don't know if that's true or not, but that was what I was told by an older lawyer. So the SRA, the Solicitors Regulation Authority, that regulates law firms and it regulates solicitors, and solicitors work in law firms. And that was what I was and am for 25 years. So early on in the process of building Garfield, because I used to have one of my side areas of practice was professional discipline and professional negligence, I am pretty conscious of regulatory law around my profession. And I thought to myself, whatever it is that Garfield might be said to be doing, I think it is conducting litigation. And if it's conducting litigation, then that is something called a reserved legal activity in our Legal Services Act, which means you have to be regulated. So then I thought to myself, well, I must go and see the SRA. So when we had an advanced prototype, I did two things. First of all, I went and saw the senior judiciary to make sure that the judiciary in our country were in favor of this sort of idea, because they cannot in any way endorse any particular product, but they can endorse the concept of products and say whether or not they like it or not. Because, of course, if the judiciary hated it, then I'm wasting my time. I should go and do something else. Maybe my garden needs more work, Yeah. So I went and saw the judiciary, and they were in favor of this sort of thing as a concept. And then I saw the SRA. And so the first question the SRA had to ask themselves was, did they have any jurisdictional basis to even regulate this? In other words, is this new thing something that is a reserved legal activity? And they weren't much assisted by our Parliament and our case law on that, because Parliament's never troubled itself to define what is conducting litigation and what is not. And case law has therefore struggled with particularly odd sort of fact patterns in trying to say whether one particularly odd thing was conducting litigation or not. But fortunately, there was enough case law on enough of what Garfield did that I was clear that we were conducting litigation, and the SRA reached the same conclusion. Having established themselves that they had the jurisdictional basis to regulate us, then the question was, well, should they? And over a sort of thorough 8-month process, They asked many questions, as was right and proper. They wanted to know about the people behind it, were they fit and proper people to be regulated to run a business like this. They wanted to know about the product. They have a public duty to try to promote access to justice, and so they wanted to understand how this would promote access to justice. And then they wanted to understand how this new type of law firm would work and whether we would fit within the existing regulatory rules and also our other ethical rules as a lawyer. And in England, we have, I'm not sure if this applies to American lawyers. I never came across this when talking to American colleagues when I was doing parallel litigation between our two countries. But in England, a solicitor is not just somebody who owes duties to their client. We also owe separate parallel duties to the court because we're an officer of the English court. So we also had to look at that, and were those duties in any way affected by this sort of product? And that ultimately was a big discussion about responsibility and accountability. And because I think I am a very responsible person and I'm certainly accountable, I think in the end they reached a conclusion that this and us were an appropriate thing to regulate.
Yeah.
I should say, though, that the
SRA... Just to answer your question real quick, yes, lawyers here are also officers of the court, so that they do owe a duty to the court and to the Constitution.
And to the Constitution. Oh, that's excellent. We don't go quite that far, but that's because we do have one, but because no one's bothered to write it down in one place. Yeah. You have to sort of search around, and it causes sort of first-year law students at university a degree of insanity to work out where it is. Yeah, I was going to say one thing about the SRA is that it's very much an evolving process. So we're regulated and authorized, but we're going to have sort of regular catch-up sessions with them where we sort of share experiences and tell them how we're doing and are there any sort of bumps in the road that we've hit, because we're not just the first, we're also the guinea pig, I think, and that's also a useful role for us to be.
You had mentioned earlier, Philip, about doing some white label arrangements with law firms. Can you explain first a little bit about what white label arrangements means, and what kind of actions that can allow? And then also, I'm curious. I know with the AI tools, the legal industry is embracing these a little faster than we have pretty much any other technology, but there's still a lot of naysayers out there. So I'm curious to see what kind of reaction you're getting from your peers in the legal community there about announcing that this is an AI driven law firm, or an AI law firm.
Yes.
So white label first, AI second.
Okay, lovely. Yes. Okay, white labeling. So we've built the platform in such a way that, as I say, it follows the process of the way a small debt claim can go. And we've assumed that lawyers would like to use it as well. And indeed, that's proven to be the case because law firms have signed up. And what we've done is we've also assumed that law firms would prefer that when it generates documentary output, that they have it on their letterhead, that they send it themselves, and that they don't have Garfield as a sort of external facing thing. So we've therefore set it up in such a way that people can put their letterhead on the system and generate the letters on their letterhead. And I think the only thing we actually do that is external facing is that because we are hooked up to the English court system, we will send the claim form and the particulars to the court on behalf of another law firm. And so that's about pretty much it that we do that's external. So in other words, it sort of sits behind the scenes and the lawyer drops documents into it and takes documents out. If a law firm said to us, we want Garfield to send the stuff to, then, well, we'd implement that. I mean, if that's what they wanted, but I'd be surprised. I always thought in practice that all of us, when we were in practice, that there's a certain amount of sort of professional pride, isn't there? And, if it's on your letterhead, it's yours. And if it's on someone else, it's definitely not, So I think that's white labeling. I'm sorry, I've lost track of the other question.
And then how's been the general reaction, pro and negative on what you've announced?
Yeah, I did worry when it came out in the FT that I'd be taken behind the proverbial woodshed and shot. That hasn't happened yet. Otherwise, unless I'm an AI avatar talking now, no. So
it's
far,
possible.
It is possible, yes. Probably do a better job than me, frankly. So far the reaction has been very positive, and I've been really I'm grateful for all of the kindness that people have sort of said in all their comments. I think people can see that this is coming and it's going to happen. That AI is going to lead to different ways of working. And the interest is really, well, what's it going to do? And is it going to not just help the big law firms with all the big resources that they can pour into this, but will it help the ordinary people and also the smaller high street law firms that do not have the ability to compete with the Magic Circle and Silver Circle firms of this world? And so I think that has meant that it's received a very, very warm reaction so far. That said, it's early days. Who knows? But so far, so good.
Nice.
So, we talk about AI improving productivity a lot, and but Garfield is directly addressing a multi-billion-pound access to justice gap in the UK. So, how are you thinking about that impact, or what impact do you want it to make? And what stories are mattering to you most as you grow this business?
So I would love to see people like Andy use it and collect in money and their life just be that noticeably bit better. I mentioned the summer holiday. They've got the summer holiday, otherwise they wouldn't have had. And then I'm going to feel that if what Sister Mary said to me when I was a young boy going to lessons after mass is remotely accurate, at least I can plead all this in mitigation in front of the pearly gates. We'll see. So yes, I hope that it will help that sort of business materially. And I think as well, it's also a demonstration of the art of the possible. So we've been able to do this. Other similar products will inevitably be launched. And many of them, I think, will be launched at the consumer space or the small business space. And so debt claims, of course, is part of the overall sort of iceberg, but other parts include all sorts of other areas of law. And I can think of plenty of cases I've heard about over the years that are for relatively small sums of money, but are really important for the claimants in question, and they've not been able to pursue them. So if those sort of products come out, then people are going to be, their lives are going to be enhanced by the fact that they can go off and have a judge tell them whether they're right or wrong. Vindicated, to use a word.
And I think you could say, I think it could possibly increase business for the attorneys that do this type of work, because it would, as you said, sometimes people want to have a person, and maybe they want a person in court to actually do the arguments, but they can get through a lot of the paperwork much faster and sort of move those cases much quicker.
I think you're absolutely right, Marlene. So I was jokingly saying to a friend of mine about a year ago, so there's I think Charles Dickens in Bleak House, that whole story is, of course, a slating of the then Chancery Court system in England and Wales. And he made the comment that the business of English law is to generate business for English lawyers, which is obviously a very cynical comment.
It's just like America.
Yeah, exactly. Well, there might be some truth in the comment. Who knows? Wouldn't want to comment on that. But I think that in answer to the concern of, well, will AI take all our jobs? I don't think it will. And I think it's going to have two impacts. So I think back 25 years ago to when I was a junior lawyer and I had hair and it wasn't grey anymore. And as a junior lawyer, you had to do an awful lot of document review and disclosure exercises and due diligence, and it was all very tedious, worthy but tedious. And what you really wanted to do was a higher level quality stuff that lawyers go into law to practice. So thinking about strategy and tactics, dealing with clients, formulating the case, coming up with the arguments, finding the right law, those sorts of things. And I think that what will happen is that AI will take away some of the more mundane, tedious administrative tasks that are involved at the moment in the practice of law, free up lawyers to do the more interesting, higher level, higher value skills, and simultaneously, because it will reduce the cost of it, certainly litigation, and I can't really speak to non-contentious work, but I can speak to litigation. I think what will happen is that a lot more cases that presently can't be pursued because they're uneconomic will become rapidly very economic. And that means that there will be more disputes. And I think the other thing AI will do is it will enhance the overall quality of lawyering. So I can think of many lawyers in my years of practice who are excellent, but I can also think of some who are non-excellent, if I could put it like that. And I think a lot of bad lawyering will become ameliorated by the fact they'll have an AI assistant on hand that will say things like, you can't put that in a letter, or that's a really bad argument, or that's a really good way to annoy the judge. And I think that will mean that the quality of lawyering will become higher, and more cases that should go further but fail because of negligence or incompetence, they won't have that problem anymore. So I think the two factors balance each other out. I think there'll be more work in terms of greater volume of work, and the lesser attractive work will drop. And so I don't think we're not going to be replaced just yet. And I've also said to people when they've asked me this question that certainly in the contentious area of practice, I think the only circumstance in which lawyers would become obsolete and redundant is if human nature suddenly changes and everyone becomes terribly reasonable, honest, fair-minded, self-sacrificing, decent people. And that's not really where the human race is at the moment. So
Yeah.
there will always be disputes.
Yeah. It was interesting. I want to pull on the thread of something you said earlier, and that is that we have the potential to mitigate what you refer to as potentially bad lawyering. Whereas before, when we talked about efficiency and scaling, if you take a bad process and you make it more efficient and scale it, it's just a bad process at scale now. Where I think we're finally, since this type of tool is something that when used correctly can actually improve the overall output and process. I think this is kind of a unicorn effect of where it could actually, like you said, improve potentially. And I think bad lawyering may be a little too harsh, but I mean, just kind of expand the ability to do more good for a client in the same amount of time. So
Exactly. Yeah.
thanks for pointing that out.
I was jokingly saying to another lawyer that I'm surprised that no one has yet built a very simple AI tool that just goes through your draft documents and removes all the adjectives and then understates everything, because that's the first thing senior lawyers do to junior lawyers. Out comes a red pen, no adjectives,
All right,
That's
Marlene,
a great idea.
There's our business plan.
Really great idea.
Yeah. If you make a lot of money, remember me.
Yeah, Philip, we'll go to the VCs right after this call and pitch this idea. So I'm going to give you kind of a hard question, because I know you've had a good 3 months of experience with your trip here in the U.S. But access to justice, even in small claims courts, is something I think that the United States is known for really falling down on. That, and I think there's statistics that potentially over 80% of legal work goes unmet, because of the process, the cost, and other things. So we have a huge access to justice problem. So if a U.S. lawyer were to come to you and say, do you think this is something that we could create here in the U.S. or another country, maybe another common law country, do you think this is something that's replicatable in other countries?
Yeah, I think philosophically, totally it is. And actually, one of the interesting consequences of the huge amount of media that's suddenly fallen upon us in the last week and a half is that I've been contacted by senior judges in other countries who have found me through friends and other contacts and said, can we talk about this? Because I think everyone's interested in trying to improve access to justice. So I think there will definitely be this sort of product rolled out in other countries. I think, however, the scale of the challenge should not be underestimated. I mean, it has taken us 2 years and an awful lot of thought and cold towels on our heads to build what we built. And also we built in a very benign environment, because the political establishment in England is very pro-AI. We've got very much a government with a growth mission and a pro-AI mission at the moment, and that's very important. Not sure all countries have got that. Secondly, the judiciary in England are incredibly forward-thinking, and whereas some countries may not have that, we have a judiciary that has been willing to say that they would like to see products created and deployed that that maybe some countries wouldn't allow. Thirdly, we've got a regulatory framework that has worked to enable it, and not every country may have that. And by that, I mean the legal regulatory framework, as well as sort of more general law. And fourthly, even things like insurance, because obviously if you've got a law firm, you've got to get insurance. And insurers are not notorious for wanting to take on novel risks as a business class, and so there's that as a challenge. And then I think as well, you've got to have a court system that has the technology that enables you to connect to it, and not all countries have got that. We are connected in England to our bulk issuing centre in Northampton, and their technology is acceptable, but even they would say that they would like it to be about 10 years more advanced. So I think you've got those sorts of challenges, and then you've got to build the product. So that's all of that, and then you've got to build the product. And the product is very much a non-trivial thing to build, I can tell you. It's taken a lot of very careful thought and an awful lot of testing to get it to the point where it is.
Philip, I want you to pull out your crystal ball. So in the next 2 to 5 years, how do you see AI changing the way law is practiced? So not just for consumers and small businesses, but for the legal system as a whole.
Okay. The first thing I'd say is that I'm notoriously bad at predicting the future. When I was in practice for many years, people would sometimes ask me, what's the next year of CYK's business going to be like? And I would always be wrong. Sometimes I'd say it's going to be the same. Sometimes it's more. Sometimes it's less. Sometimes I'd say it'd be more and it was less. So you can't. Predicting the future is incredibly difficult. I think if I was going to go out on a limb, what I would say is that the uptake of AI and the progression and scaling and deployment of AI products is just going to accelerate. And the art of what is possible is becoming more and more open all the time. So people are thinking of increasingly novel products. And I think in the legal space, it's very much a question of when, not if. AI is there that sort of is an AI assistant that supports you as a lawyer, or even one step further and is a sort of thing that we've built where it is also able to conduct a particular matter by itself. What I would say is that no one should panic, because I'm very conscious of the current state of technology, and I would not myself feel comfortable where we are at the moment with trying to handle much bigger claims, because I don't think the technology is nearly capable enough for that, because the complexity of cases is not a linear increase. I think it's more of an exponential curve. As claims get bigger and more complicated, there's more parties. And so I think that the technology would have to become exponentially more capable to go up the value chain. So that's where I am at the moment. I think if you'd asked me 3 years ago, what will you be doing in 3 years' time? And then you'd said to me, you might be the CEO of a law firm that's just launched an AI product, I would have laughed and laughed and laughed and said, whatever you've been drinking, it's good stuff, because there's no chance. So, I mean, that's why I can't predict the future. Who knows? But I think it's going to be a very interesting time. And I think if I was a junior lawyer, I would be not just working on my legal skills, I'd also be working very much on my technological skills, because I think they will hold you in good stead going forward.
Agreed.
Right. Yeah, our summer associates just started this week, so I will take this clip of you saying that and send that to them. So,
in that case, also do everything Greg tells you, because you'll
exactly. Yeah, a 20-pound note is coming your way. Thank you. Well, Philip Young, co-founder and CEO of Garfield AI, thank you very much for taking the time to talk with us on the Geek and Review. This has been fun.
Yeah,
thank you very much. Thank you for your invitation, and it's been very nice to speak to you, and also to sort of have a Texas to England connection here.
And thanks to all of you, our listeners, for taking the time to listen to the show. If you enjoy it, please share it with a colleague or give us a shout out on LinkedIn or Blue Sky.
And Philip, we'll put links on the show notes, but if listeners want to learn more about you or about Garfield AI, where would you direct them?
Well, the first thing I'd say is I'm incredibly uninteresting as a person, so they definitely shouldn't try and look me up. But why not look up Garfield AI at www.garfield.law. There's some videos there. There's a speech that was given by Lord Justice Burse, who is the Deputy Head of our Civil Litigation, talking about how this sort of technology can really help the court system. So things to look at.
And as always, the music you hear is from Jerry David DeSica. Thank you, Jerry.
Thanks, Jerry. All right, talk to you later.
Okay, bye.